appeals to order. First item is a roll call.
Chris Bird,
Present?
David Connick,
Present.
Alex Sharp,
Present.
Jennifer Matthews.
Present.
Bill Anderson.
Okay.
And before we go any further, I'd like to introduce to you Lynn Tomasello. She will be replacing Candy in the office. And so she's here tonight to gain a little experience. So she's going to type the minutes for us tonight.
Great.
So,
Okay, well, thank you. Okay, the next item is the adopting the agenda. Are there any suggested changes, additions?
Yeah, I've got a suggestion.
Okay, Mr. Connick.
I think this F1 ought to be deleted.
Okay,
And the reason is, the case is over, the case is dismissed. And it's been dismissed for more than 21 days. So whatever you've got in your, whoever's proposed resolution that is, whose suggestion was it, if I may ask, to put that on the agenda?
well, hold on. Let's determine whether we want to remove that.
Okay, well, anyway, it's a moot point. The case is moot, the case is dismissed, 21 days are up, the court doesn't have any jurisdiction over the matter after 21 days, and
I move that we accept the agenda as circulated and posted.
Is there a second?
Yeah, I'll second
Okay, is there any further discussion? All in favor?
Aye.
it. Aye.
Nobody opposed?
you know I'm opposed.
Okay, so there's one opposed. Okay, the next item is, and I'm not sure what I'm doing with this, but this is just the notice of this public meeting. It was properly done. And do we have copies of this for people?
no, I did not.
Okay. If anybody wants to see this, it's right here. And this relates to tonight's meeting. Okay, the new business dismissal with prejudice, and Mr. Connick gave a little introduction to that. But basically, my understanding of the issue is that you did offer to non-suit, or did non-suit it, but you can still bring it back up. And so our interest is in having it dismissed with prejudice, so the issue is done and will not be brought up again.
I have a copy.
So,
Here's a copy. Unfortunately, Board Docs is not working tonight. I don't know what the problem is. So I'm not able to pull it up. There is a copy back there if you needed it, if
We all
you've
have
not seen
copies.
it.
and then the other issue that, and Jennifer and I had some conversations about this before the meeting, if you want to know where it came from. And I think the other thing is that we wanted to go on record as indicating that suing the board and its members individually is not acceptable. So that's, I think, the other purpose of this.
Yeah, how do you propose to proceed, Mr. Chairman? Are you gonna let me speak to it? or
Yes,
you just-
yes, I will, but I just
Okay.
wanted to give a little introduction.
All right.
Okay, is it anybody who'd like to speak?
Well, yeah, I mean,
Mr. Connick?
I'll listen to the rest of the board members and I'll give my thoughts on it, if the board is so inclined to listen to it.
We are. Is there any further thoughts from others?
No.
No, not at this time.
Bill? No. Okay.
Well, my first question before I say anything, thank you, Mr. Chairman, is who wrote it?
We consulted with the county attorney,
And on what authority? Who's we?
Me,
Jennifer.
And on what authority did you consult with the county attorney is what I'd like to know. Because the state code and the zoning ordinance is very clear that only the board has the authority to authorize the hiring or consultation with counsel. And the last meeting where that issue came up was the August meeting in September. And at the August meeting, which was before this particular appeal, when it was on the docket for it to be scheduled for a hearing, on Mr. Anderson's motion, I believe, who, as memory serves, said no offense, David, but why hire a lawyer when you don't have to? The board voted unanimously not to hire counsel at that time. In September, we had a meeting after this suit was filed and so forth. The appeal had been withdrawn at that point in time. Nobody said a word about it at the September meeting. It never came up. In October and November, the board didn't have any meetings at all. So I repeat my question, on what authority did any member of this board consult with the county attorney or anybody else? Maybe the board, had they discussed it, would have decided not to hire somebody who appeared before this board in August on this very matter.
Art
And-
Goff did?
No, Peter Luke did, and said, I think you recused yourself, so I believe you were here though, and said that he had a conflict of interest and he couldn't represent the board in the matter. So, maybe we would have gotten somebody, if we were going to get counsel, if that was the decision of the board, but that's not really the issue, because the board never took a decision to hire counsel, or to authorize you, or Ms. Matthews, or any other member of the board to consult with counsel. So again, repeat my question, on what authority was anyone consulted, and on what authority was this drafted?
I would say you're not gonna get an answer to that tonight.
Why not?
I'm just saying you're probably not gonna get an answer tonight.
Well, okay, maybe I'll get an answer some other time.
Okay.
As to what's in here, my view is that most of what's in here is completely without merit. And if you'll give me leave to do so, I'll go into why I think that. But I think it's very unfortunate that the board, rather than to discuss what led up to this lawsuit, which was, number one, an erroneous interpretation of law with respect to who is entitled to appear and be heard at a public hearing before this board and who is not. And I sent the board a memo, I think it's dated September the 21st. And I would like to, I don't know where it went, because it was submitted in writing and it was submitted electronically to all you members. But it's 6 pages long. I have a copy of it. And here, and if I would like to have it put in the record, because that goes through chapter and verse of all the Virginia Code sections.
I don't think we're trying this case right now. We're just
Well-
saying you did not have the authority to sue the board
Well,
and the membership as the secretary to the board, which is what you did.
well, that is not what I did.
Well,
It
it
is
says,
exactly what you
comes now David L. Connick pro se in his capacity as acting secretary, and that came out of your lawsuit.
It's directly word for word out of your lawsuit.
So, and that,
Well,
So
that's
say that-
who I was.
but you had no authority from this board.
I don't need any, I don't
You
need.
said you were in your
Are
capacity.
you gonna let me
as
say
acting-
what I have to say, or are you gonna argue with me?
I'm not gonna argue with you. but
Good,
that's-
then I'd like to
Okay.
finish, and
Why
then
don't-
you can have the floor,
Can you
Ms.
do this in
Matthews.
5 minutes?
No, I can't do it in 5 minutes, I don't think.
Well, let's try if we can. But go ahead. Go ahead.
Well, for all the reasons that are cited in this memorandum, every single section of the code and our zoning ordinance and our rules of procedure is very clear that at any public hearing that we have, including public hearings that are held on appeals, any interested or aggrieved party has a right to be heard. And what happened back in September is that Ms. Matthews unilaterally decided that wasn't gonna happen.
What does that have to do with this?
What does it have to do with? Well, that's the predicate of the lawsuit.
No, but that might be the predicate.
Well, I don't know what you're holding up when you say this.
According to this, you don't have the authority to do the suit. That's what we're speaking.
Well, I absolutely do have the authority to do it, and the reason that I have the
Let me
authority to do
interject,
it.
hold on, one thing. There was the option of discussing your point at this meeting,
Well, the
which
meeting,
you chose not to.
the meeting,
Or let-
and by very interesting contrast, Mr. Chairman, at the November meeting, which was a specially scheduled meeting, you didn't give the proper notice under the Freedom of Information Act, and when that was brought to your attention and the rest of the board, I assume that was on your authority, the meeting was canceled. And I would have been happy to discuss it at a meeting, but the meeting wasn't properly noticed. And I did discuss it with the board by way of 3 or 4 different emails that went to Ms. Matthews and the whole rest of the board, detailing why no proper notice had been given under the zoning ordinance, which requires 5 days written notice, and no proper notice under the Freedom of Information Act had been given, which requires 3 working days or 3 business days notice of a meeting, and Ms. Matthews didn't comply with either one of those when she noticed her special meeting. And I just asked her to call it off and postpone it, and she refused to do so. Now, my position is that just because I'm a member of this board, whether I'm a member or I'm acting secretary or anything else, I didn't give up my right as a citizen of the Commonwealth under the Freedom of Information Act, which guarantees every citizen of the Commonwealth the right to enforce the Freedom of Information Act. And that was what the suit was about. That's the main part of it. That the acting chairman and the board proposed to have an illegal meeting. And you asked me a very interesting question, and now I'll give you the answer. Why couldn't I just discuss it? Well, I'll tell you why I just couldn't discuss it, because it put me, just as it says in the complaint, which you read one little section of, one little phrase out of, I don't remember how many, well, I have it here, but it's 30-some pages long. It's 25 pages long, I believe, the complaint part. Maybe I'm wrong on that. But, no, I'm sorry, that includes the exhibits. Just a second and I'll tell you. You read one phrase out of 12 pages.
What was the opening phrase?
Well,
That's okay, okay.
you already said what it said, but the point is that the reason, as it said further on in the complaint, if you bothered to read it, it said that you were put, not you because you recused yourself, but I was put in the position of the Hobson's choice of either coming to an illegal meeting and participating in it and violating the Freedom of Information Act, or not attending the meeting and not presenting my views on what was done, and I didn't want to do that, and I shouldn't be forced to do that, and that's what the case was about. So you all can have your own views, and I respect that. I don't agree with them of whether it was legal or not legal. You don't have the power or authority to tell me or anybody else what's legal or not legal. You people are bound by what's in the state code. And the state code is very clear in where it says that what the powers and duties of this board are. And the powers and duties are to hear appeals, to grant special use permits, to interpret the zoning map, and to grant variances. There are 8 things that are listed. And disciplining the members is not one of them. That's the prerogative of the circuit court judge, not you. Pontificating and passing resolutions about who did what and whether it was legal or not legal is not in your authorized powers. And there's case law, the Board of Zoning Appeals of Fairfax County versus the Board of Supervisors of Fairfax County. And the Supreme Court of Virginia said, boards of zoning appeals have only those powers expressly granted, period. So here's the sections, if you want to look at them, 15.2, 2308, 15.2, 2309, there's 1, 2, 3, 4, 5, 6, 7, 8 powers. None of them authorize any kind of resolution like this, and our own zoning ordinance, section 170-140H, has the same 1, 2, 3, 4, 5, 6, 7, 8, and it's got a couple other ones like to do a budget and so forth. It's got 12 powers there that are just a different enumeration of the same ones out of state law. You can't do this. You have no authority, no legal authority to do it.
Okay, that's an obvious statement, thank you.
Okay, so
Hold on, is it any further discussion?
From me?
No, from anybody else?
Oh, why are you cutting me off?
Because I think we get your point.
Well, I'm not finished, Mr. Chairman, so I guess I'll write another dissenting opinion.
Okay. Should we have a motion to end the discussion? Is there a second?
I second.
All in favor?
Aye.
Aye. Okay. Is there a motion to approve this resolution?
I so move.
Is there a second?
I second.
Is there any further discussion? All in favor?
Aye.
Aye. Opposed?
No.
Okay. Thank you very much.
See you in court.
Mr. Chairman, is there no public discussion?
No public discussion. No public discussion. Okay, so the next item is the Kirchner Tourist Home.
This is special use application 160902, John Michael Kirchner and Mary Walsh. The summary is that the applicant and the leasee desires to use the house to operate a tourist home. Parking is available on the property. Meals will not be served. The home is located directly off Sperryville Pike and has a private drive. The tourist home will never be rented for more than 30 days or to more than 4 people at a time. The neighbors have been notified with no complaints as of this writing. Neighbors are not close by to be impacted by noise, light, or traffic, and the leasee will be near the home to manage any issues which may arise. This is regarding property tax map 39, parcel 8. It's zoned agriculture. It's in the Stonewall Hawthorne district. The address is Walnut Run Farm, 4323 Sperryville Pike, Woodville, Virginia. And it's a house plus 16.33 acres. This was heard before the Planning Commission. The use is allowed under 170-36E with additional standards and 170-66K. And the Planning Commission review was that restrictions as stated in the proffered application should continue, and that the permit should not transfer beyond the current owner and leasee.
But we did not get a copy of that.
Of that,
You did not.
Okay, that's fine, that's fine.
I don't know whether it's can put it in there.
No, that's all right.
Okay, so who is here to represent would you come forward, please? And would you state your name?
John Michael.
You're welcome to come up here. I'm gonna swear you in. You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. You're welcome to come.
I'll stand.
Okay. Yeah, just tell us a little bit about what you're proposing.
I'm just trying to make mortgage. My wife is sick, my partner of 33 years, and she's up in Rhode Island, and 2 incomes is now 1 income, and I'm just trying to make up where I'm
Excuse me, I can't hear.
I'm sorry, sir, if you gave me a chance to speak earlier, I wouldn't have been disrupted.
Well, you don't have to speak while he speaks. Thank you.
I'm just trying to make mortgage right now, so I don't desire to do this. I've been sort of forced into doing this.
Okay. That's,
It's
and
the
then what's
extent.
in the application?
Yes.
Okay.
And you live in Woodville
Yes.
proper?
No.
Is it any questions from the board members?
Will you be managing the property,
Yeah.
the turnover,
Oh, yeah.
cleaning and all that kind of thing?
planning commission met on this?
The planning commission met on this, they seemed to have no problem with it and approved it unanimously.
Okay. I'm gonna open the public hearing on this application. Is it anybody here who'd like to speak about this application? Mr. Frazier?
No, I wanted to speak earlier,
Oh,
sorry.
okay. Is it anybody else? Okay, then I'm gonna close the public hearing. Is there, what's the pleasure of the board?
I propose that we grant this motion.
Okay, is there a second?
Grant this motion, what does that mean?
We're gonna approve this
Approve
special
the-
use permit.
Well, that's not what he said. He said, I move that we grant this motion.
Well,
Thank
approve
you.
this application.
Is there a second? Go ahead.
Yeah.
We're gonna have a chance for questions? Or no?
I didn't get a chance to ask any questions.
No, I wanted to ask some questions.
That's what I was, gave us a chance. I'll let you do that.
Thanks.
We're having a second, and then you can
Oh.
go.
Then
I'll
we
let
open
you
for
do that.
discussion.
Fine.
Did we get a second?
Yes, I like these.
The secondary restrictions. Okay.
If that was the one. Actually, this is a paper that's first owned as a private road, I think it's good.
So is that a second?
I'll second.
Okay, Bill Anderson seconded it. Okay, Mr. Connick, go ahead and ask a question.
Yeah, this road that leads into it, it's all on your property?
Yes.
All the way out to the road? So
Yes.
nobody else uses the road?
Nobody else uses the road.
Okay. And you're gonna live on the property, you're gonna still live there, or?
No, when it's rented, I go to a friend's house.
I see. And is that local, or is that?
Yeah, it's local.
I see. Okay, that's all the questions I have. Thank you.
Okay, is it any other
No,
comments? or-
no, it's just, that it was good that these other,
I think they were enumerated. so-
yeah, remunerate, yeah.
Okay.
Mhm.
Okay. So there are some restrictions that you have offered that we're going to accept, I believe. Is that correct?
Yes.
Okay. Is it anything further, Mr. Connick, we should do right now
What?
on this application?
What are you asking me for?
Because you must have an opinion. Okay. All in favor of approval of this application?
Aye.
Aye.
Aye. All opposed?
Abstain.
Abstain. Okay, so the application's been approved.
Thank you.
Thank you. Okay,
Thank you.
and then I think that's, there, we don't have minutes, do we?
No, we do not.
Okay,
And what's coming up on the next set of agendas?
do we have anything coming up that you know of?
Nothing that I'm aware of. I'm
Was that
anticipating
one-
a couple of applications,
The
but we haven't
one
gotten.
from last month?
Oh, that's
is
right.
that
Charlotte
coming
Taylor will be in January.
In
We've not
January.
heard from her. She's still on
Okay.
vacation, but
You think that
we're
will come?
anticipating her.
Okay. Is there a motion to adjourn?
Make a motion to adjourn.
Is there a second?
I'll second the motion.
All in favor?
Aye.
Aye.
Thank you.